Hello and welcome to Wisconsin in Focus, powered by the Center Square. I'm JD Davidson, the Center Square Midwest Regional Editor. Joining me today is Ben Yount, Wisconsin contributor for the Center Square. Ben, how are things today?
Well, it is the end of dry January. Not that I ever tried it, but, for those who did, they made it through their marathon, and now they get rewarded with a drink on what was actually a rather pleasant Midwestern winter day. So, maybe they could take it out to the patio to enjoy their return to non-sobriety.
Yeah, we talked about this last week, but I love the Midwest when the sun is out and it's 40, it's shorts in almost t-shirt weather. And I lived in the South for so long that this would be minus 20 degrees in the South the way they would react.
There was a little bit of frost on the windshield this morning. And knowing Southerners, they have no idea. They don't have snow brushes or scrapers. And it would paralyze Charlotte, North Carolina to have, a bit of frost throughout the morning.
I lived in a little town and we'll get to the topic soon, but I lived in a little town called Fort Payne, Alabama. And when we would get snow, none of the people at the newspaper that I worked at they assumed they weren't coming to work. There were no snow plows. They did not have salt trucks or brines so I said, "Oh no, you're coming to work. I'll come get you." And I had to shovel the entire parking lot just to keep the newspaper open down there.
That's dedication.
Thanks. We're recording this on Thursday, February 1st, 2024. So Ben, for more than a decade, Wisconsin's Act 10 has seen its share of state and federal court challenges. There's another one going on as we speak. First, remind our listeners what Act 10 is.
Act 10 is what brought a camel to the Wisconsin Capitol back in 2010, 2011. Act 10, it was the landmark defining law for former Governor Scott Walker. It's the reason that the Cheesehead Revolution was what it was and why Walker was considered a darling to run for president back in 2015 before his campaign just sort of imploded on itself. But no, Act 10 essentially redrew the rules for how teachers' unions specifically could negotiate with local school districts. It said the only thing that you can talk about is base salary, that there's nothing else that you can bend schools over the barrel and take them for all they are worth. Because before that, it was all manners of other benefits, other boosts to pay, other things that the private sector just could not keep up with. And those negotiations, again, Civics 101, schools are local government. And when they pay their teachers more and 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 more, somebody else has to pay that money. The money comes from somewhere. And that meant tax increase after tax increase after tax increase. And so when Republicans in the Wisconsin legislature approved Act 10, it instituted a recall. They tried to just kick Scott Walker out of office. They sued and sued and sued and sued. But Act 10 survived. And now here, a decade plus later, it saved taxpayers about $17 billion. Now, one of the key things, if you are worried about our friends in the public school teachers unions, one of the key provisions of Act 10 is that it limited raises to the rate of inflation. And for most of its existence, that meant 2%, 1.5% kind of raises. Well, during the explosion of inflation that we've seen here under President Biden, teachers unions across the state took full advantage of that and went and got the biggest raises that they could. So teachers are continuing to make more and more and more and more. And I'm sure we'll do a podcast come this spring about all of the school referendum questions that are going to taxpayers to raise taxes even more. But this is something that now, a decade on, a lot of schools that may have been against Act 10 back in 2011 are certainly for it because it has saved people money. But this was on that list of what does the new liberal majority Wisconsin Supreme Court want to get rid of? It's not just the abortion law. It's not just Wisconsin's gerrymandered legislative maps. Act 10 is right there at the top of the list. And so here we are with another challenge designed solely to get Act 10 back to the Wisconsin Supreme Court with the hope that the Protasiewicz court will drop kick it off the books and go back to the way that things were in 2010.
So what is the challenge specifically now?
It is an equal protection challenge that the challengers say Act 10 treats police officers and firefighters differently than it treats public school teachers unions. And they're saying, well, laws are not allowed to treat people differently based solely on their occupation. Defenders, including the Wisconsin Institute for Law and Liberty, say, yes, state laws are allowed to do that. You are absolutely allowed to have a law that affects different people differently. Think of laws that, don't apply to young people, but apply to older people. Think of the difference between laws that affect corporations and laws that affect individual people. The reality is it doesn't matter the specifics of the challenge. The intent here is simply to get Act 10 to the Wisconsin Supreme Court or in front of a friendly judge, and the judge then can take a pick. Remember, the justification for striking down Wisconsin's 1849 pre-Roe abortion law was that a judge in Dane County said, I know that this law mentions abortion, but it really doesn't mean a ban on abortions. It means a ban on killing babies, like live babies who've actually already been born. And if a woman wants to end her pregnancy, this law that specifically talks about it doesn't apply at all. And so that's sort of the thought here of it doesn't matter what the specifics of the challenge is, as long as the case gets to the Wisconsin Supreme Court. The people who have hated Act 10 now for almost 15 years will be quite satisfied to put this up again for the court to decide. But Will's defense is that, look, when you force people to join unions, which is one of the other freedoms that Act 10 gave, was, now all of a sudden you're not required to be in the union in order to be a teacher. When you force someone to join a union, that violates their First Amendment rights of free speech and free association. And when you take money from them, that's also a constitutional violation. So it's going to be interesting to see what was the case out of Illinois that dealt with AFSCME. Janus. The United States Supreme Court said in Janus, you can't force people to do this. You cannot force someone to join a group against their will. And so we'll have to see what the Protasiewicz court can write that would strike down Act 10, but also live under the framework of Janus. But hey, you know what? This is why it's fun to be the correspondent in Wisconsin. I don't know that they have these problems in North Dakota.
Most likely not. And we've been talking about it for 10 to 15 years, and I'm sure we'll talk about it again. Right now, though, that's all the time we have. Listeners can keep up with this story and more at thecentersquare.com. For Ben Yount, I'm J.D. Davidson. Thanks for listening, and please subscribe.
Like to stay informed on the go? Audible has an ever-growing selection of audiobooks at your fingertips. Whether it's that classic you've been meaning to get to or the new release you've been waiting for, follow the link in our show description to get 30 days of Audible free.